So good morning to all attendees, dear colleagues, dear friends. I would first of all like to congratulate the person who has worked as the main investigator of this symposium. I mean Nelle Schudt from Ghent University, who suggested the topic and who contacted me some months ago to inquire whether I would be willing to co-organize the event at the University of Strasbourg. And here we are. I know Nelle has put a lot of time and energy into this symposium, so thanks again. I'm very pleased to announce that great speakers and chairs, experts in climate science, legal sciences, history of sciences, scientific mediation, have agreed to give a talk today. So many thanks to all of you. Nelle and myself are very honored also to have members of the European Court of Human Rights with us today, joining us as speakers and audience. As you probably are aware of, some climate cases are currently pending before the Strasbourg court, but it is perfectly clear that we are not allowed to mention them as they have so far not been dealt with by the court itself. Before saying a few words about the topic, I would also like to welcome all participants online on the YouTube channel of EMISHA. I must say we have had a big success so far, attracting nearly 400 persons online. Many thanks from all over the world, Australia, China, Europe, so that's amazing. Many thanks also to all those of you who have decided to attend in person. Please note that the symposium is filmed and recorded and displayed online on the YouTube channel of EMISHA, as I have just mentioned. Videos will be available from the EMISHA website and from the DISSECT EIC. I would like to add that we got funded by Ghent University, the DISSECT EIC team. Nelle will say a few words on that. My research laboratory, SAGE, and the Strasbourg Research Initiative in Sustainability and the Environment, FERED. Many thanks to our institutions for their support. I also wish to thank Céline, Latifa, Melis, and Natalia for their help during the day. All my gratitude to Camille and Sylvain, who are behind the cameras and behind the computers today for us. Let us turn to the innovative topic we have decided to cover. As you all know, the last 10 years have seen an increasing number of climate cases for which human rights courts have the possibility to play a big role in order not to leave climate change victims without redress. The European Court of Human Rights is facing its first climate litigation applications and will hold its first public hearing on the 29th of March. For sure, it's not the first time that human rights courts need to consider scientific facts. And the European Court of Human Rights, like other human rights courts, have been in charge of dealing with environmental cases for at least 4 decades. From my previous publications, I have noticed, notably after analyzing Article 8 environmental judgments, that scientific causality often represents a blind spot in the court's reasoning, or is considered with a certain degree of flexibility and or as one factor among others in an overall assessment of the case, what Katalin Suliok, who is with us on Zoom today, has clearly revealed in her wonderful book. The other aspect I would like to mention is the fact that supranational courts on such sensitive and complex issues very much look at the way domestic courts have used scientific facts. And here we have seen many instructive, but at the same time, many diverse uses of science. What is no more controversial is that European and other regional human rights courts, which are general courts, are not necessarily well equipped to deal with complicated scientific knowledge. The first category of questions which we probably need to address today is as follows. Are there any peculiarities regarding climate science? What I have in mind, is there any difference between environmental science and climate science, which is of any relevance to human rights tribunals? Is it because climate science is a lot about attribution, so that it speaks to experts in law? Actually, there exists a need for courts to trace back climate change and specific harm to state conducts. Climate science has rapidly progressed in the understanding of attribution, so that science can inform causation and also be useful when we come to decide about damages. Which comes to another issue. What sort of science do human rights courts need? Or maybe there is no such specificity, but climate cases are different because they engage many defendant states at the same time. Hundreds or even millions of victims in the same case are about future generations, collective rights and duties, concepts which are foreign to the interpretation given so far to the European Convention of Human Rights. So climate change implies a change of scale. The second category of questions probably emerges from the concept of translating, which is in the title of our symposium today. Why would climate science need to be translated, mediated to magistrates? Is it the responsibility of climate scientists to do that? Who are the intermediaries, if we need any? Scientists in charge of fundamental research and judges need to keep their independence and stay in separate spheres. Yet, climate science is needed for policymakers and the judicial sector. Do climate cases offer the opportunity for human rights tribunals to reassess the way they address causality and science? It is also obvious that as climate science forces public authorities to take a stand and that it is disruptive, in reaction, it has therefore given rise to the emergence of false science. How should human rights courts make the distinction between relevant and less relevant science? Should the research unit, for instance, at the Strasbourg court, be consolidated? At the same time, from a legal theory perspective, some argue that scientific truth, if it happens to exist, and legal truth do not necessarily match. The primary purpose of law is about justice, not about truth, as stated by our Swiss colleague Alain Papot. Dworkin supported the opinion of an autonomous legal reasoning, and I'm quite sure that many judges sitting at human rights courts would support that view. Moreover, climate cases are not only about scientific knowledge, but more broadly about political and ethical choices to be made democratically. There now exists a consensus as to the fact that most of climate warming is due to human activities, and so science has informed us about the state's substantial contribution to climate change. In environmental cases, I also notice the importance given by the court to measures taken or delayed by states to respond to the risk of violations. So I cannot imagine why human rights courts would not be able to decide on European states' responsibilities for the negative impact of climate change. As is usually the case, complexity lies in the details, and it might be challenging First, to determine the respective share attributable to climate change and to other factors, if there are any. Second, to allocate responsibility between state and non-state actors. And third, between states themselves, since climate change is essentially a global problem. As you see, this symposium should cover very important issues, and it offers a great opportunity for experts in law and experts in climate science to discuss together around the same table. So the program is structured around 2 panels. We have deliberately put scientists and lawyers together. The first panel will be about how to better connect what seems to be so far disconnected, scientific evidence and litigation strategies. The second panel will concentrate more on the remaining challenges and think about solutions to evidentiary hurdles in climate cases. So I'm more than excited to listen to you on those aspects and probably on many more. I do hope that this symposium offers us a great opportunity to exchange and make emerge brilliant ideas. And I'm happy to give the floor to Nelle for more introductory remarks. Thank you.
Esteemed colleagues and friends, first and foremost, my heartfelt thanks also goes out to Elizabeth, without whom this event truly would not have happened. Thank you so much for being a fantastic host, welcoming us here at MISHA. I'm absolutely delighted to extend my greetings to everyone present, here from all parts of the world, both in person and also online, joining us as speakers and as attendees. What was envisioned as a relatively small event has gathered quite a bit of attention, and I think it only goes to show that this topic truly hits a nerve in our current climate, and this is without pun intended. To name but a fraction of cases with an advisory opinion on climate change sought from the Inter-American Court of Human Rights, a final draft resolution formulating a request for an advisory opinion before the ICJ having been uploaded a mere 10 days ago, and indeed the Strasbourg Court entering their first set of hearings on climate cases at the end of the month, the broad interest in our symposium should not really surprise me, because climate science and the potential use in it for climate litigation is relevant to all of these initiatives. Our ambitions for this event remain humble and shall be clearly stated. We're not trying to reinvent the wheel today. Instead, we wish to pick up on a twofold aim. One is to share insights and knowledge on some of the most up-to-date climate science. And two is to open up or continue a dialogue amongst professionals from both the science and the legal disciplines on how climate science could be translated and used in the human rights courtroom. As an academic, I've been curious about science and climate litigation since starting my PhD in 2020, which, by the way, was also one of the hottest years ever on record. I'm affiliated to the European Research Council's DISSECT project led by Professor Marie-Bénédicte Dombourg, whose research group comprehensively maps evidentiary regimes of the 3 regional human rights bodies, as well as the UN human rights quasi-judicial bodies. This work is guided by the idea, and here I quote Marie, that evidence is at the heart of adjudication, and adjudication at the heart of the international protection of human rights. Within this group, I've carved out my niche of researching the challenges arising from the introduction of complex scientific evidence in environmental and indeed climate contexts before 2 human rights courts, the Inter-American and the European Court of Human Rights. My research has led me to consider the court's role in fact-finding and truth-seeking, something that Elizabeth has also spoken on, and I'm very curious to continue this discussion today, perhaps. I've studied burdens and standards of proofs in various environmental and climate cases, and it has brought me to the Strasbourg Court last summer, conducting interviews and engaging in conversations with various members of the court to better understand how legal personnel indeed approaches scientific evidence in a number of cases. Now, science and law is clearly not a novel topic altogether. The Strasbourg Court, which self-identifies, and I've heard this on numerous occasions, as a generalist court, has handled complex topics ranging from interstate conflicts, finance, medical negligence, torture, IVF, euthanasia, digital technology, and of course this list goes on. This point, I think, should be emphatically stressed. The court is capable of and has dealt with specialized expertise for decades. And yet, climate cases pose particular challenges, and I hope that some of these challenges will be addressed in our conversations today. The questions I am particularly curious about relate to how and to what extent can we expect courts to engage with, properly weigh, and assess complex scientific evidence. What are the specific challenges in the climate context? And what are the benefits and potential drawbacks if courts choose to refrain from making use of the available science? Whilst I will leave it up to our fantastic speakers today to discuss the relevance of novel climate science and approaches for translating such climate science for the courtroom, I would like to take a few minutes to dive deeper into the theoretical underpinnings of weighing the pros and cons for considering scientific evidence in the first place. So, why then should we deem the incorporation of climate science as important? Now, I would argue that legal epistemology plays an important role in understanding the importance of properly incorporating science into judgments. Gardiner, for example, explains that legal epistemology provides us with an understanding of how knowledge, justification, and explanation form the basis of a claim, and how collective beliefs are formed by judges and juries. In the context of a judgment, epistemological considerations require an analysis of the judge's methodology when reaching a conclusion based on factual evidence. Sheila Jasanoff, whose pioneering work in science and technology studies deals extensively with how the law impacts the way we view evidence and proof, explains that neither law nor science traditionally seek to intensely scrutinize knowledge claims asserted by the other discipline. In her eyes, this hands-off approach, though, is challenged in the climate litigation context. Climate litigation, she asserts, and I quote, increasingly requires a closer interaction and confrontation between the two fields, as judges are faced with the difficult task of having to assess complex, oftentimes novel, or not so novel, but relatively unknown scientific evidence. Sul-Yok, whom we are also lucky to have as chair today, has also discussed the importance of adequate incorporation of scientific evidence in the environmental law context. She raises the risk of producing so-called Solomonic judgments, whereby common sense is used without properly considering the available scientific evidence. This, in turn, could call into question the court's ability to handle technical cases and impact the court's overall authority. In practice, this means that when judges are called to determine whether states have adequately implemented environmental policies capable of upholding the fundamental and human rights of its citizens, they must base these considerations on sound science. In other words, a legal claim which has its epistemic foundations, namely assertions resting on the science, can hardly be dealt with without incorporating, at least to some extent, such scientific evidence. So why exactly might judges be hesitant in engaging too far with scientific evidence? For one, we of course cannot expect judges to magically turn into scientific experts, nor would we want them to. One specific risk is that scientific evidence may be incorporated incorrectly, leading to false conclusions and thus epistemic arbitrariness. D'Aspremont and Mbenge in this regard have explained that, and I quote, methods of science and methods of law are not interchangeable or mutually supportive in every case. So, testing scientific claims based on legal methods could gravely distort the knowledge claim's validity or meaning. To provide a practical example where courts truly quite struggled to combine flawless legal reasoning with climate science was in the otherwise hailed for various reasons groundbreaking case of Urgenda against the Netherlands. As pointed out by Meyer and indeed other scholars and scientists, the court relied on outdated calculations for mitigation targets from 2007, which gave them the increasingly difficult task of combating the climate crisis and reaching ambitious targets. In Meyer's words, may have become significantly more expensive in 2016. Now, what we hope to discuss today is some of the novel climate science that has become especially relevant in aiding courts tasked with adjudicating on intersecting questions of science and the law. And so to come back to the aspirations for this symposium, we hope today to strengthen the bridges between the different disciplines and to ignite a much-needed dialogue as to how we can collectively combine our strengths, our expertise, our wisdom and imagination to adequately respond to the planetary crisis we're facing. With policymakers having largely failed us, and at most having responded to climate change in a far too slow a manner, it is obvious that courts play a crucial role as separate arms of power to scrutinize whether governments continue to act in violations of their duties under various obligations, including, of course, human rights obligations. adequate use of climate science, particularly novel findings from attribution science, for example, which we will hear about later on today, might aid in overcoming various procedural, substantive, and doctrinal hurdles indeed for the court's analysis. So with this, I will lead over to our fantastic panel. Let me introduce the chairs. We have Katalin Suljok online joining us, and Christian Bonin in person here with us today. So over to you. Thank you.